All right, guys, so hopefully you've already watched part 1 of this PowerPoint lecture for Chapter 7, which dives all into the issue of arrest and searches incident to arrest, which we'll cover here in a second, and use of force, deadly force, okay? So right now I'm going to walk you through that very controversial yet extremely important topic of use of force and deadly force, because rightfully so, it is an area which deserves a lot of scrutiny, but a lot of understanding by you, not only as a citizen, right, but a student and a future criminal justice professional, because probably about 90% of the cases I defended in Louisiana dealt with use of force-based issues, okay? So let's go ahead and dive into this material. All right, so y'all should see the use of force continuum. So the use of force continuum is demonstrates, it reflects the amount of force you as an officer can use depending on the situation. Now, before I even dive into this use of force graph, I want to point out the fact that every single arrest, guys, every single one has a use of force in it. If an officer simply takes your hands and places the handcuffs on them as gently as he or she can, that's a level of force. So the question is, how much force is okay? When does that officer cross that line of permissible versus impermissible, okay? So by an officer showing up on the scene, that details a level of force, because just by your mere presence, you're showing a person or persons that they need to comply, whether that's to respond to your questions or to submit to your authority in some way, shape, or form, right? Tactical communication is when you as an officer would say, stop, or empty your pockets, some type of verbal command, right? Physical control, of course, is when an officer places you down to sit down on a curb or turns you around to place handcuffs on you. Then as you get to level 4, 5, and 6, you get into the more defensive, proactive, and reactive methods that officers use, okay? So let's go ahead and to get into this, I would like for you all to watch this video with me. So hold on as we open this. Let me make sure my sound is on. Let me go down. Sorry about that. Ooh. Okay, here we go. Here's the video. So I want you to go ahead, and this is local, guys. This is San Marcos. This was a Texas State University student. So wait for a second while it pulls us up to play. Sorry, it's taking a minute, guys. All right, here you go.
Do you know either one of us? Okay. Do you have any guarantee he's not going to grab a gun and start shooting? Or I'm going to have to start shooting at him? I know you're not. Okay. Do you have any of that? Okay. But why do you walk in between the scene right here? You don't know what's in this car. You don't know the danger in this car. You don't know what I have in my car. Okay. What could you have done? Walk all the way around back to find everything. You're not involved.
Not parked in the middle of a walkway.
I have pulled over us. I'm doing a traffic stop. I'm taking action. Okay. You don't walk in the middle of it.
Police officers. This is
Okay, well, that's immaterial right now.
It's immaterial that you're asking me. I said nothing to you. I was walking to their car.
Why don't you go that way, walk around behind the car, and go
Why don't you park that way and
okay, it's not a parking situation.
This is not a parking situation. Exactly. So I should be able to walk to wherever I want.
Okay, you're walking in the middle of my scene, and you're bothering my scene.
I feel like y'all are bothering the total establishment of Rooftop, and I know the owners. And I am a criminal justice major, so I can. No, you can't walk.
Okay.
Let me see your badge.
It's right there.
Well, where's your actual badge?
ID.
I am over 21, so I can go wherever I want.
do it in just a second.
Okay, my friend has an ID, but that's irrelevant to why I'm walking by, because I'm not in a bar right now.
Your name on it. You just came out of this place.
Alexis Alpha. There you go.
You just came out of this place, so obviously you had to have your ID when you got in.
Honestly, you're the bad news. I've done nothing but walk to my car to go home. I have work tomorrow.
Man, I think I have said it myself. No,
obviously, he's just and he's just taking it out on me.
Okay, all right.
You can't take it.
Hey! Dude, what the? No, what the was that? Dude, what the was that? Hey, what's your badge number? Give me your badge number now. Hey, Paulino, give me your badge number. Hey, step back.
All right, guys. So you guys should get the drift. Hold on, I go back to our PowerPoint. Okay, so y'all saw that. First of all, don't ever tell a police officer, I'm a crim major and I know what I'm talking about. That's a good way to get in trouble, right? Don't do that. Don't be that person. But in any event, she was walking in between the cars, apparently was blocked off otherwise, and then he takes her and slams her to the ground, right? Did he tell her that he was going to apprehend her before doing that? No, there was no indication that that's what he intended to do. He just went for it, right? So, whoop, sorry about that. So as we walk through, and I put this basically in here, but she had, and if you go to the end, she went to the medical center. She had actually chipped a tooth, had physical abrasions on her face and in her arms and on her side. Like, he really threw her down pretty hard, right? I think you could see that from the video. Now, in exchange, there was a plea deal. He didn't face any civil damages or criminal damages. Rather, he surrendered his badge in exchange for serving any time, okay? Now, you may ask yourself, why didn't he get in trouble? Why didn't he serve any time? Why didn't he face any monetary damages? Well, let's dive into that and really explore what factors are considered in that. So, in order to determine whether or not use of force is appropriate, you have to ask whether or not it's reasonable and necessary to make the arrest. If it's not reasonable and necessary, that's when it can be qualified as excessive. And so his actions, that officer's actions, were deemed by the court to be excessive, okay? So instead of, again, facing any type of punitive punishment for his actions, he just accepted a plea deal, meaning he didn't have to serve time, he didn't have to pay money. He accepted a plea deal, surrendering his badge in exchange for avoiding any type of other punishment. So you cannot use any force to make an arrest except minor levels of force to put on handcuffs or escort the person, right? Now think about that use of force continuum that I had earlier. To determine whether or not it's objectionably reasonable, meaning it's reasonable and necessary, first ask about the severity of the crime. Did this person just commit an assault, or did they simply steal a Twinkie? There's a drastic difference in how you'll treat these two separate type of offenses, right? The second is, does this person pose a threat? Is this person drunk and belligerent, throwing blows, or is this person merely mouthing off, right? Now, it has been deemed by the Texas Supreme Court that if a person says F you, and I'm not going to say the actual word, guys, but you know what F you means. If an offender says F you, I think you effing suck. That's not reasonable and necessary or any type of justification to use an elevated amount of force on that subject. They have a First Amendment right to say those type of things, okay? Even if a person flips off an officer, that's not justification to arrest them either, because again, it may not be nice, but you have a First Amendment right to be an a-hole, right? So by apparent threat, they mean a physical threat, meaning is that person using rocks? Are they chunking rocks at people? Are they look like they might have a gun, a knife, something of that effect? Do they pose a physical threat? And does the person, are they trying to run away? Are they trying to resist being arrested? So use or threat of use of physical violence against an officer, does satisfy this third thing. So whether or not you're looking at their resisting arrest, if the person says, F you, you'll never get me, I'm not gonna let you handcuff me, that qualifies as evidence that they're resisting, okay? But if they just say F you, that's not enough. And then using any other means which creates a substantial risk to themselves or to the officer. So the officer doesn't have to get hurt to satisfy that. We don't have to wait till somebody actually gets injured. The whole goal here is to be proactive, to not respond in a way that isn't necessary. Remember, it has to be reasonable and necessary. So you don't have to wait till the officer gets stabbed or shot in order to use an elevated amount of force. So curse words, verbal objections, again, they're not enough. First Amendment right to be a butthead. The last one is that actions are judged from a reasonable officer standard. So the courts recognize that officers are faced with really hard situations. They're faced on a daily basis with situations that require a split-second decision, okay? And so taking that into consideration, they look to see, well, did they in that moment have a reasonable belief that their physical safety was threatened, that other people's physical safety was threatened? All of those different factors, 1 through 4, are considered. So in order to help you guys remember this, I want you to remember CTP triple R. CTP triple R. So you look at the crime. What was their crime? Were they posing a threat? Did they resist arrest? Were they posing a physical violence? What risks did they pose? And what was the reasonable officer standard? So CTP triple R. That's a good way to remember the use of force standards to consider. Now we get to deadly force. So you cannot discuss deadly force without understanding where it stems from, the standard. So if you hear somebody talking about, I don't think he was justified, or I think he was justified, he could have shot that guy, I want you to tell them, well, what does Tennessee v. Garner say? And if they don't know, then educate them, okay? So Tennessee v. Garner is what opened the door to police liability, okay? So in '85, very sad case, a neighbor heard their neighbor's house getting broken into, right? Late at night, they hear glass breaking, they look out their window, and they see that the glass is broken and somebody's moving around inside. Now, notably, the person who called said they don't think that that person was armed. So I'm assuming that they saw the person actually enter into their neighbor's house. So it turned out that it was a 15-year-old named Edward Eugene Garner. So he broke into that house, and when the cops arrive on the scene, they know that he's in the backyard at this point. So they go into the backyard, and they see him about to jump over the fence. He's hanging on the fence. So his back is toward them. They tell him to stop. He doesn't stop. He begins to pull his leg over the fence to escape, okay? When he does that, they shoot him in the back and the head, killing him. So they said they did that to prevent him from escaping over the fence. That's one way to do it. I mean, definitely if you're dead, you can't escape. So they shot him, he died. Now, when they had the officers on the scene testify in court, they admitted that they did not see or fear that Garner was armed, okay? But this is something I want you guys to note. In Tennessee at this time, it was legal to shoot somebody who simply committed a felony. Now think about what could be a felony, guys. Are all felonies violent? Nope. So let's say you steal 500 Twinkies from a gas station, or you get gas and you drive away, right? You commit some type of act that's non-violent but still considered a felony. In Tennessee at this time, it was considered legal to use lethal force. So the question here was it okay? And excuse me while I move my laptop. It's in the sun, so I don't want to lose my laptop here. Okay, so there we go. Now it's in the shade. So the question here was whether or not the officer could be held liable, even though in Tennessee at that time, it was completely legal to do that. So the Tennessee District Court authorized the officer's actions. They said he committed burglary. Burglary doesn't have to be committed in a violent way. In fact, most burglaries, if not all, are committed in a nonviolent manner because the whole purpose is to commit the offense when nobody's home, okay? So despite that fact, Tennessee said it's a felony and they're allowed to use lethal force, meaning deadly force. So also the court said that Garner, he faced the risk. He knew that if he committed that act that he could be caught, and if he could be caught, he could be shot by officers if he resisted. So they deemed it acceptable, okay? Now, I included the actual oral argument from this case, and I highly suggest that you listen starting at 16 minutes and 9 seconds until about 25 minutes. So about, what is that, 8 minutes or so in total, because it's fascinating what the court focused on in order to come to their ultimate conclusion. Now, the father later filed a Section 1983 claim. So that's basically a claim saying, I know I can't sue him criminally because we can't prove intent, but I want to sue him for money damages. So he sued, and it reached the Supreme Court. And there, the court said, no, Tennessee, you got it wrong, okay? So from the Tennessee case, they came up with a new standard. So deadly force can only be used in defense of the officer's own life, in defense of the lives of others, and last, if there's probable cause that that person was involved with committing a physically serious violent crime. Those are the three elements, guys. If the officer does not fear for his own life, if he doesn't have justification for fearing for the lives of others, and if he or she just has a suspicion, that's not enough. He or she cannot use deadly force. So the bottom line from the Tennessee v. Garner case is that you as an officer, you can't use lethal force to seize an unarmed, non-dangerous suspect by shooting them dead, period. Okay, so the issue in courts is typically whether or not the officer reasonably believed that the suspect was armed and dangerous. This is where most courts, and I'm sorry, my neighbor's dogs go crazy, but this is where the courts typically have a hang up with the jury. The jury typically has difficulty saying, well, that officer couldn't have reasonably believed that, or there's no way the officer could have thought that. That's why 9 times out of 10, an officer is not charged criminally. Because guys, remember, in order to convict somebody of a crime, you have to prove beyond reasonable doubt, right? Well, if you right now, think about if you're in a classroom with you and your classmates, and I ask that if I show a video and I say, how many of you think that lethal force is justified? Do you think everybody would agree? The answer is no. There's always going to be 2, 3, 4 people who say, I think it was fine, whereas others will say, no, that was not fine. So that's why it's very difficult to charge officers on a criminal level. So most cases against officers are in civil court, meaning money damages. So take that into consideration. Now let's look at a different case, Graham versus Connor. In this case, Graham needed juice. He was a severe diabetic. He was having a physical issue as a result of his diabetes. So his friend decides to go to a gas station, get him some juice. When he goes in to the gas station, it's packed, okay, just packed. So instead of waiting there, he rushes back out and peels out in his car. Well, what do you think the cops thought when they saw that behavior? They thought that he had just robbed the gas station. So they immediately start following Graham in his car. They stop the vehicle and they see that Connor, the diabetic man, is acting very erratic. This is specifically what he did. He got out of the car, he was mumbling his words, he wasn't speaking clearly. And one thing to note is when some people have a reaction to diabetic issues, their breath will smell like alcohol, okay, despite the fact they haven't drunk a drop of alcohol. So the officer didn't know of this situation. All he knew is that he was faced with somebody who was mumbling, stumbling, slurring their words, smelled like alcohol, and then Connor started to run around the car, just run around and around and around. And the officer's telling him to stop, but he doesn't. Then Connor passes out on the ground, right? Well, his friend is trying to tell the officer that, look, he's having a reaction. I'm trying to help him, so on and so forth. But Would an officer take the word of somebody in that situation? Maybe, depends. So the man sustained really serious injuries when he fell, okay? The officer had arrested him as a result of suspecting that he was drunk and on drugs, and as a result, they sued, right? Now, the Supreme Court held that that wasn't excessive force, that it's tested again, would a reasonable officer have engaged in the same level of force? If you were an officer and you were confronted with somebody who smelled like alcohol, was stumbling, mumbling their words, running around the car like a madman, what would you think? A reasonable officer, based off of their experience, would think they were dealing with somebody who was high or inebriated. So as a result, that officer wasn't charged either criminally or was not responsible at a civil level, meaning didn't have to pay any money. So I want you guys to take note from this case that the reasonableness of one's actions depends on what would the typical officer think when faced with those same circumstances, those same dynamics. Now, a common question that people ask is, well, wait a minute, he or she could have easily used a taser. They didn't have to use a gun. Now, the answer to this is in the Drinsky case. In Drinsky, the court said that they don't have to use the least lethal means, that it just has to be reasonable, okay? So officers aren't forced or required to use a taser as opposed to a gun. It depends on the circumstances. They don't have to use the least lethal means. So as a checklist, I want you guys to, let me move my face here, to use this moving forward. So when you look at whether or not the level of force used was reasonable, you ask, what was the crime? Was the suspect posing a threat or risk? Were they trying to resist or flee? And then use the reasonable officer standard. If deadly force was used, you ask those top 3 questions, okay? But I want to note something and highlight it. Every semester I have this happen. That third element of deadly force, you guys, they have to have probable cause. I mean, they have to have facts and information that that person did in fact commit a crime that was physically violent. Burglary is not physically violent, okay? So remember Garner. It no longer is satisfactory that that person simply committed a burglary. That person, that person has to have committed a violent crime, and you have to have probable cause that they did that. All right. So I'm going to quickly go into searches incident to arrest. So when you've been arrested, officers can search you, okay? So the only 2 restrictions on that is that it has to be a lawful arrest. I mean, the officer has to have probable cause to arrest you, and it has to be timely. Now, this is referred to as contemporaneous, meaning the officer can't arrest you and then 2 days later search you. It has to be within that same sequence of events. You're arrested, searched, taken to jail to be booked. So this is often attributed to the Chamel case. In Chamel, the arrest warrant was for burglary of a coin shop, right? And this is one of my favorite cases because the officers knock at the door, wife answers the door, and they tell her, look, we have an arrest warrant for your husband. We have reason to believe that he robbed a coin shop, and she's mad, right? She's pissed. So she allows them to stay in the house and wait for her husband for like 5 hours, right? The husband finally shows up, and when he does, they don't just search him. They search the entire house, and they find tons of evidence against him. So the question is that additional information, that additional evidence against him, is it admissible in court when they didn't have a warrant for his home? A search warrant for a home is not the same as an arrest warrant, okay? And that's all they had. So the court said, no, that's not okay. It's unreasonable. And they created what I refer to as the Chamel TwoStep. The Chamel TwoStep is this. You can only search a person who's been arrested to remove weapons, and then 2, to prevent evidence destruction. That's it. So you can't go upstairs or in their garage to keep looking for evidence. You can only search within their immediate surroundings. So when I say their immediate surroundings, I mean their wingspan. This is known as the arm span rule. So when an officer, if they go like this with the offender, this area around the person is the area in which they could possibly have a weapon or have evidence that they could destroy. So this is the only area in this region that an officer can search. Now, as a side note, this is Michael Phelps, the Olympic gold medal swimmer. How insane is it? His wingspan is almost twice the size of me, almost 7 feet long. That's insanity. So no wonder he always gets first place. All right, so remember, in order to justify a full search incident to arrest, there must be a lawful custodial arrest. So the officer has to intend to take that person into custody. So in this case, United States versus Brown, somewhat recent, 2005, a person was arrested for public intoxication, but the officer didn't have probable cause. They suspected the person might be drunk, but they never did a breathalyzer. They never did a sobriety test of any kind. They just simply arrested him. Now, when they were in the process of arresting him, they patted him down and they discovered a gun. Is it admissible, folks? Y'all know the answer. No, because there wasn't probable cause to even arrest Brown for public intoxication. So if there's no probable cause to arrest the person, then there's no authorization to search that person, period. So a full search for traffic citation stop. So if you're speeding, an officer can't search your person because evaluating the two factors under Chamel, officer safety. Well, if you're just getting a speeding ticket, that's a brief encounter with an officer. And evidence destruction, well, they already have the evidence. They clocked you at speeding. So what other evidence of speeding could they garner by searching you? And the answer is none. So for traffic citation stops, an officer is not justified to do a full search on you. All right, so moving forward, custodial arrests for minor crimes do justify a search incident to an arrest. So in United States versus Robinson, the kind of old case, a trucker was essentially driving one of those massive trucks, right? The semi trucks. And in order to drive those, you have to have a special operator's permit. If you don't, it's considered a crime. And that makes sense, guys. Think about how big those trucks are. They can cause a lot of damage if you were to come into contact with one of them, getting a wreck. So when they discovered that he didn't have the right authorization, they were arresting him. And they did a full search of him, and they discovered in his cigarette pack, heroin. Okay, so the question was the heroin admissible? What do you guys think? Yes, absolutely. Apply Chamel. Now, the contemporaneous aspect of the search incident to an arrest requirement means simply that you have to conduct the search pretty shortly after you arrest a person. So typically the red flags start to raise if an officer takes more than 10 to 15, 20 minutes to arrest and search the person. So 30 to 45 minutes has, by the courts, been deemed too long, okay? So red flags start to go off around 20 minutes, and then 35 to 45 minutes, too long. That's not considered timely. There is an exception, though, like there is to everything, and it's known as the Edwards-Goodwill exception. If it's not feasible for an officer to search a person immediately after being arrested, then the courts will understand this, but you have to justify it. You have to show them that you had good reason not to. So in a 74 case of United States versus Edwards, guy broke into a building, was booked, and put in jail. Now, they believe that they have probable cause that on his clothes there are paint chips from the scene that would connect him to that crime, right? But here's the problem. They didn't have any substitute inmate clothes for him. So their choice was, do they seize them and make him stay in a jail cell naked, or do they allow him to keep on the clothes till the following day when they get new clothes and then seize them? Well, guys, if they make him stay naked in a jail cell around a bunch of other inmates, what constitutional amendment comes to mind? Cruel and unusual punishment, right? So they could be sued for cruel and unusual punishment, or they could just wait a little bit. So the court said, despite the fact they took a long time to seize those clothes as evidence, they had good reason to delay the search. Nobody wants a naked inmate sitting around, right? Now, in terms of the scope, officers can search anywhere on the person that weapons or evidence may be found, okay? So seize all evidence found, not just the evidence of the crime at issue. Now, one thing to take into consideration is that your textbook is outdated on one very important aspect. You can conduct non-intrusive searches of the body. So search the pocket, search the purse, search with anything within the wingspan, right? You can even take hair samples, fingernail clippings, as long as they're painless. But in order to do naked body versus penetration type searches, you have to have very strong reasons for doing so, because that's extremely intrusive. Now, blood samples used to be permitted, okay, for arrestees, but that has changed. So now, in order to make somebody give a blood test, you have to have, excuse me, you have to have a warrant, period. So these 4 factors that existed before, I think, 2016, they don't exist now. You have to have a warrant, guys. So watch this video clip when you have time, because this is the clip that started it all. This is where a nurse was arrested because she wouldn't conduct a blood test on a non-consenting patient, okay? So this is the case that opened the door to now requiring all officers who want to get a blood test to have a warrant. Now, again, you can search anything within the person's immediate control, right? So that includes containers. So if the person is getting arrested and they're in their car and they have a box next to them, that is within their immediate control and you can search it. So, excuse me, but if it's not immediately associated with the person, so say for instance it's in their trunk, doesn't count, because that person can't, within their wingspan, reach into their trunk from their driver's side in order to access something. So no, realistically, what can the person reach? All right, guys. So let's look at this. Officers arrest a man for narcotic possession on a street corner. They take him to his home 2 blocks away and discover a significant amount of drugs. Is this permissible? Now, guys, I really hope you all just immediately answer this in your heads. No. So why? Before we do this, because can he reach to inside his home 2 blocks away? No. And an arrest is different than a search warrant, okay? Now let's look at the second one. Man's arrested in his trailer for armed robbery. The officer finds him lying in bed. Officer searches under the covers for a gun while another officer restrains the man who is resisting. He also searched a box at the foot of the bed and discovered 2 revolvers. Is that admissible? Texas or the Chamel TwoStep? And the answer is yes, because he could easily just sit up in bed and grab what's in that box, right? So again, officer safety, prevent evidence destruction, and must be close to the timing of the actual arrest. So that's it, guys, for the second part. If you guys have any questions or need any help, as always, let me know, all right? I look forward to hearing what you guys have to say.